Good afternoon to all of you. Those of you who decided not to have lunch, but to come to this meeting for your lunch, you're most welcome, and I'm sure you will not regret this. My name is Niels Blokker. I'm from Leiden University, the Netherlands, and I welcome you to this session on the role of international organizations. The theme of this year's annual meeting is adapting to a rapidly changing world. And it's obvious that many of the changes that are taking place in today's world bring challenges for international law. But it's also obvious that during the last few decades, international law has developed rules and institutions to deal with these changes. Indeed, this is exactly why international organizations have been created, to manage change. The creation and functioning of international organizations is one important way in which the international community is trying to meet the challenges of change. So you have taken the right decision to come to this panel. Kofi Annan stated some 16 years ago before the UN General Assembly, state sovereignty in its most basic sense is being redefined by the forces of globalization and international cooperation. What the hundreds of existing international organizations have in common is that they have been created because states considered it in their common interest to cooperate within a permanent framework in areas in which states could no longer perform their functions in isolation. This is true both for organizations created as early as the 19th century, such as the Universal Postal Union, and for those created later and having all the acronyms that you may know or not know. It's also true for the UN, it's true for the European Union, and it's true for what is one of the most recently established international organizations, the International Commission on Missing Persons, created in December last year. The question to be discussed in this panel is what role international organizations have played in the processes of adapting to a changing world. To what extent have they been able to provide stability where this was required? For example, by offering mechanisms for the peaceful resolution of conflicts, by UN peacekeeping operations, or recently by the creation of the OSCE Special Monitoring Mission in East Ukraine. To what extent have they been able to promote change where this was necessary? For example, by improving the UN financial sanctions regimes. Before I will introduce the panelists to you, let me mention three things I had in mind when proposing and organizing this panel. First of all, many international organizations were created long ago. The oldest, the Central Commission for the Navigation of the Rhine, was created exactly 200 years ago. Many organizations were created during and after the Second World War. The powers and institutional structures they have reflect the time of their creation. But the world has profoundly changed. Have international organizations been able to keep pace with changes that occur in the areas in which they carry out their functions? If so, how? If not, why not? What should be improved? Secondly, there have always been opposite views of international organizations. There are the popular stereotypes of that international organizations are either static, sluggish bureaucracies, or too dynamic mission creepers. More sophisticated is the distinction between international organizations as fora and as actors. The more traditional view is that international organizations are mostly fora, frameworks available for states to cooperate when they want. According to another view, many organizations are more than just fora. More than the sum of their members, they are also autonomous actors. Already in 1961, UN Secretary General Dag Hammarskjöld outlined essentially these two views of the UN in the introduction to his annual report. The UN as a static conference machinery on the one hand, and the UN as a dynamic instrument on the other hand. These views have implications for the role one may see for international organizations in dealing with changes in international society. If you prefer the first view, it is for the member states to use international organizations in taking up current challenges. If you prefer the second view, it is also for the organizations concerned to do so. Always, however, it is fundamental to distinguish between the role of the organization and that of its members, as we have seen in recent years when rules were developed on the responsibility of international organizations, and when cases were brought in this area before national and international courts. Thirdly, it is a must and it is fascinating to analyze developments in practice in this field. So much is happening in practice. As Einstein said, die Welt vor uns, ein geöffnetes Buch, wenn wir es nur lesen können. In English, the world before us is an open book, if only we were able to read it. Academics need to calibrate, rethink, and where necessary adjust their fundamental concepts and views. Otherwise, they will not be able to see and understand how, in practice, international organizations and their members try to find solutions for nowadays' challenges. Therefore, most of the speakers in this panel have extensive experience in the law and practice of international organizations. Let me now introduce the panelists to you. In view of the time, I will do so very briefly. But let me say, first of all, that I'm very grateful that all of you immediately accepted the invitation to speak here. We are fortunate to have such qualified panelists. First, we will have two very experienced high-level legal advisors of international organizations. Steve Mathias, Assistant Secretary General for Legal Affairs of the UN, and Lisa Tabassi, sitting next to him, Head Legal Service at the Organization for Security and Cooperation in Europe. And before that, she was in the legal service of the CTBTO PrepCom, and then another acronym, the OPCW in The Hague. So she has extensive experience with 3 international organizations. They will discuss how the international organizations they serve have been able to adapt. And they will also discuss how legal advisors can contribute to promoting the rule of law when international organizations respond to developments in practice. Next, it is a privilege to have Kimberly Prost with us, the UN Ombudsperson of the Al-Qaeda Sanctions Committee. I think there is great and broad respect, with the exception perhaps of the European Court of Justice, for the way in which she has brought life into this new institution over the past few years and has made it into a truly independent review mechanism. As a final speaker, we have Professor August Reinisch, sitting at the right end of this table, from the University of Vienna, who is well known from his publications on the law of international organizations. He will look at international organizations from a different angle. He will discuss the need to develop a body of law that is binding on international organizations, given the accountability questions that have emerged since international organizations have become independent actors that now often perform functions traditionally carried out by states. As always in these panels, our time is limited. In order to also have some time for questions and discussion, I've asked the panelists to speak not longer than 15 minutes. This is the same as the 15-minute guideline for statements by world leaders in the general debate of the UN General Assembly. But I will be a much stricter enforcer than the President of the General Assembly. So let me now stop and first give the floor to Steve Mathias.
Well, thank you very much, Niels, and thank you to the organizers for inviting me to be part of this panel. I'd like to suggest that the United Nations has been a laboratory of adaptation for the 70 years of its existence, and that evolutionary adaptation is the larger part of what the United Nations has done during that time. Perhaps we can begin by noting that peacekeeping was a very early adaptation, but has become a most significant activity of the organization. There are now over 120,000 peacekeepers, police and civilians in the UN peacekeeping missions around the world, and the peacekeeping budget far exceeds the regular budget of the organization. But adaptation is an ongoing process, and there have been many adaptations in the history of the United Nations, including recent ones. And this afternoon, I'm going to touch on the UN role in addressing the chemical weapons in Syria and on Ebola. And I'll also discuss some adaptations to the adaptations, particularly in the field of peacekeeping. But I'd like to begin by asking what we mean by adaptation and suggesting that I think it can refer to an instance where an intergovernmental organization is undertaking functions that may have not have been contemplated expressly in the constituent treaty that creates it, or it's undertaking functions that were contemplated, but in a way different from that which was contemplated in the constituent treaty. Now, of course, in any case, the applicable legal treaty regime must be consistent with the adaptation that's being suggested. And I think that the United Nations is particularly open to adaptation, given the very broad purposes that are set out in the Charter, the broad range of responsibilities of the various organs of the UN, and the flexible rules under which it proceeds, including the ease with which UN bodies can establish subsidiary organs. And I would also note, in setting out the legal context, the relevance of the doctrine of implied powers, as developed by the International Court of Justice, and the relevance of the practice of the organs of the organization, as also confirmed by the ICJ. And I'd go further, and I would suggest that the attractiveness of the UN as a forum for adaptation may also have been enhanced by its universality, by its legitimacy, and by its comprehensive and widely accepted privileges and immunities. Finally, I'd just like to note in this respect that one aspect of adaptation that may not be noted so frequently is the difficulty in eliminating entities that have been created once they're no longer needed. And for us, this has sometimes been a challenge. And one might point at the current situation with respect to UNMIC as a case in point. Now, who does the adaptation at the United Nations? I think in the first instance, it is the member states acting through the intergovernmental bodies. And if there is a subsidiary entity to be created, it would normally be done by one of the intergovernmental bodies. But I note that even in this context, the intergovernmental body, the General Assembly or the Security Council, is frequently proceeding on the basis of a report by the Secretary General. And so even in the case of action by the intergovernmental bodies, there is an integral role for the Secretariat as a catalyst for adaptation and change. But implementation of UN programs is generally done by the Secretary General and by the Secretariat acting on his behalf. And in the course of implementation, adaptations may also take place. Additional adaptations may be introduced. And I want to use as an example of this kind of adaptation the recently adopted policy at the United Nations called the Human Rights Due Diligence Policy. Now, as the nature of peacekeeping changed, that is, fewer peacekeeping operations in interstate wars and more in intrastate conflicts, and increased attention by the security councils for the support of national institutions, one factor that developed was that the UN might find itself on occasion supporting non-United Nations security forces that may themselves be responsible for violations of IHL or human rights law or refugee law. And in fact, in the Democratic Republic of the Congo, the United Nations had the specific mandate to assist the FARDC in its activities. But it developed that credible allegations of violations of IHL and human rights law were being made against the FARDC. And so the question became for the organization, how can the United Nations ensure that it does not become complicit in any way in this wrongdoing? And so a policy was developed, which was initially in the context of the DRC called the conditionality policy. And it essentially established conditions that would attach to the provision of UN support to non-UN security forces. So those are essentially threefold. First, where a UN entity is contemplating providing support to non-UN security forces, but it has substantial grounds for believing that there is a real risk that those forces may commit grave violations of IHL or human rights or refugee law, then the United Nations is obliged to refrain from providing that support. And if a UN entity is providing support and subsequently receives information that those forces to which it is providing support are committing grave violations, then the United Nations must intercede with the command elements of the security forces with a view to putting a stop to the violations. And if those violations continue nonetheless, then the UN entity must ultimately suspend or withdraw the support that it's providing. Now, as I say, this policy was developed within the Secretariat, and it was developed in a context in which there was a Security Council mandate to provide certain assistance. But nonetheless, the notion was that the organization must condition that support in a certain way. And I'm glad to say that this policy adopted by the Secretariat has subsequently been endorsed both by the Security Council and the General Assembly. And it continues to have a real vitality. And those of you who have been following recent developments in the Democratic Republic of Congo know that MONUSCO has refused to provide support to forces commanded by two generals who were suspected of committing such violations in the past. So this is one case among many. There's also a human rights screening policy that applies to UN hiring, and the policy on sexual exploitation and abuse. And all these policies were driven by the Secretariat, essentially, put on top of mandates that existed from one of the intergovernmental bodies. And of course, another broader kind of example of this kind of adaptation is the development of the political role of the Secretary General, the good offices role of the Secretary General, which is only sketched out in the Charter, but over time has developed into a major area of his activity. Now, not all adaptations to adaptations are driven by the Secretariat. The member states, through the Security Council or General Assembly, also continue to refine the adaptations that they've created. And peacekeeping is another example of that kind of work by the Security Council, because what we've seen over time is this tendency toward more robust mandates, and of course, in this regard, the establishment of the Force Intervention Brigade in MONUSCO is a good example. And we've also seen the Security Council enhance the role of regional organizations by, for example, creating UNAMID as a hybrid mission between the United Nations and the African Union. Another way in which adaptations are suggested or progressed within the system is through the creation of high-level panels. And a recent example of this is the expert panel on technology and innovation in peacekeeping from last year, which focused on the desirability of introducing new technology into peacekeeping missions. One example of this is unmanned, unarmed aerial systems, which make the possibility of monitoring the conflict on the ground much more efficient than had been the case in the past. And so what this panel has suggested is the development of a new set of MOUs with technology-contributing countries. And these would mirror the policy, the agreements that already exist for troop-contributing countries and police-contributing countries. And the panel also suggested certain ways in which new technologies could be introduced, including consultations with the host state. So there are a variety of ways in which these adaptations can be introduced. Now, I said I was going to talk briefly about the chemical weapons in Syria and the Ebola cases. In the case of the chemical weapons in Syria, it became clear early on that what was going to be needed was some mechanism that could combine the technical expertise of the OPCW with the legitimizing authority and the operational capacity of the United Nations. And so the lawyers set about creating a joint mission established by the Secretary General and by the Director General of the OPCW, with the approval of both the Security Council and the Executive Council of the OPCW. Now, this was not an entity that had legal personality. It acted through the Director General and the Secretary General. But it made it possible for the efforts of both entities, the OPCW verification expertise and the UN political coordination and liaison, logistical support, security, information assessment, communications and outreach, and administration, to be well combined and efficiently combined to do its work. Now, the challenge in the case of Ebola was a bit different because the support that needed to be coordinated was not just between the UN and one other entity, as in the case of the chemical weapons, but across the whole range of the UN system. And so it was determined that the model that was used for the chemical weapons in Syria would not be efficient for the Ebola case. And in that case, we proceeded on a different basis. And the Secretary General himself established UNMIR, not as a subsidiary organ of the Security Council or a subsidiary organ of the General Assembly, but rather as an administrative unit within the Secretariat. Now, this was done after notifying both the President of the Security Council and the President General Assembly of his intention to create the mission. The General Assembly welcomed his intention. So it was clear that there was political support for it. But it was unusual in that it was not a subsidiary body of one of the intergovernmental bodies, but rather a freestanding unit within the Secretariat. Now, in each of those cases, the lawyers played a critical role in developing the documentation to support the way that they would operate, in interpreting the mandates, in defining the proper roles and responsibilities for each of the entities, and drafting the legal instruments that were necessary to preserve the status, privileges, and immunities of the United Nations and of the sister organizations, as well as taking measures to minimize the potential liabilities of the United Nations and the other organizations that were engaging in highly difficult work. So in that case, there was a variety of agreements with the host states, with the neighboring states, with the states, the transit states. All these agreements have to be negotiated and created on a sort of custom basis by the Office of Legal Affairs. Now, Niels asked more broadly, what is the role of the lawyers in adaptations? And in our experience, it varies. In some cases, for example, the international criminal tribunals, the role of OLA has been absolutely fundamental. Those tribunals were, to a large extent, conceptualized, their statutes were drafted, and much of the negotiation of the statutes took place with OLA involvement. We also frequently advise DPKO and DFS in feeding proposals that we think are important into the drafting of Security Council resolutions. So even though we don't have a seat in the table, through DPKO and DFS, we can sometimes have influence on the relevant provisions of Security Council resolutions. And we also provide advice on what can be called the vehicling of Security Council decisions. For example, in some cases, we might advise that a resolution is required. In others, we could advise that a presidential statement would be adequate for the purpose. In still other cases, we might advise that an exchange of letters between the Secretary General and the President of the Security Council would be suitable for the purpose. So there's a range of possibilities in that regard. Now, what is the future of adaptation? If we go back to the certain expenses case of the ICJ, the court stated there that when the organization, the United Nations, takes action that warrants the assertion that it was appropriate for the fulfillment of one of the stated purposes of the United Nations, the presumption is that such an act is not ultra vires the organization. Now, if we conceive for a moment of the very broad and aspirational purposes stated in Article 1 of the UN Charter, I think we can be optimistic about the possibility that the UN will continue to be available as a laboratory for adaptation in the interests of we, the peoples of the United Nations. Thank you.
Thank you very much for sharing with us some of your experience at the UN. And we will now quickly go to the next speaker, the next legal advisor, Lisette Bassi from the OSCE Legal Office.
Thank you very much, Niels. I want to thank you for the opportunity, and to ACIL as well, to speak here today, which is a great honor. I will just start off, since this is adapting to change, by mentioning that the first international organization that I worked for, the Iran-US Claims Tribunal, we did not have laptops, cell phones, or the internet, or even PCs. We were still working with word processors, which those days the system was as big as a piano. So we had a lot of equipment sitting around in various rooms and coping with that. I think the hugely important technology changes have really driven us to become instantly responsive, very mobile, and transparent, which I think is a good thing, but it's quite a pressure. It's clear that international organizations are only competent to act as far as the powers attributed to them permit. So the tension between the state sovereignty of the member states that created the organization and the fundamental principle of independence has sometimes led to protracted debates in the organs of the organization and efforts to limit the activities of their secretariats and their executive heads. In the brief time allotted, I would like to talk about 3 cases in which the organization has successfully gone way outside its mandate, and each time for humanitarian reasons, and this was allowed. The first case is the OPCW and paralytic shellfish poisoning, which is quite different than the Syrian operation. After the treaty entered into force, it became quickly apparent that there was an urgent health issue that had come about because of implementation of the treaty. The treaty requires that its 190 states parties adopt import-export controls over the chemicals of most concern for chemical weapons proliferation. And the Schedule I chemicals are the ones that are the most serious, and they're very strictly controlled. This led to a problem because there is one Schedule I chemical, saxitoxin, that is involved in paralytic shellfish poisoning, which attacks the nervous system of humans that eat contaminated shellfish, kills them in 15 minutes, and there's no antidote. So there was a trade in saxitoxin to calibrate the test kits in the ocean for these red tides in which the paralytic shellfish poisoning would occur. And the import-export controls was leading to a delay of sometimes 6 to 8 weeks in the transfer of these kits. So Canada proposed that the treaty be amended to allow for the instant transfer of these kits for humanitarian reasons. There was a lot of pessimism among states and in the Secretariat that it was risky to reopen the treaty, to start amending it, that it would be opening a Pandora's box. But much to our surprise, because of the humanitarian need, it was quite routine. It went in an expedited fashion, which is provided for in the treaty for technical changes, quite routine, not politicized. It went through, and then these kits could be traded around the world. So that one was very easy. The second case is the CTBTO Preparatory Commission and tsunamis. The 1996 Comprehensive Nuclear Test Ban Treaty is aimed at preventing the vertical and horizontal proliferation of nuclear weapons by prohibiting the testing of such weapons and any other nuclear explosions. It's not in force. In the meantime, the Preparatory Commission for the CTBTO has been set up as an international organization to carry out the necessary preparations for entry into force of the treaty, including the preparing the operational readiness of the 337 facilities which will form the international monitoring system as part of the CTBT verification regime. The IMS stations globally employ seismic, hydroacoustic, infrasound, and radionuclide technologies to monitor vibrations in the earth, the oceans, the atmosphere, and for the presence of radionuclides in the air, which may suggest that a nuclear explosion has occurred. After entry into force, the data from the IMS stations will be used exclusively for verification of compliance with the CTBT. At least that was the intent of the drafters. During the preparatory phase, the IMS is being provisionally operated by the Preparatory Commission, and the data gathered is transmitted directly to the headquarters in Vienna and in near real time to the states signatories of the treaty for test purposes. On 26 December 2004, there was a devastating tsunami that occurred off the coast of Indonesia and killed almost 250,000 people in 14 countries. The later analysis of the IMS seismic and hydroacoustic data concluded that the CTBTO PrepCom had received advance warning of the impending tsunami a full 2 minutes in advance of any tsunami warning center in the region. In terms of saving human lives, 2 minutes is very significant. So there was a very protracted debate in that case among member states that did not want to go outside the intended use of the data. They thought that this was dangerous both for the mandate of the Preparatory Commission and the later CTBTO, the intended use of data, confidentiality, et cetera. Finally, the PrepCom did approve explicitly for humanitarian reasons and on the basis of a model cooperation agreement the transmission of IMS data to tsunami warning centers that had been recognized by UNESCO. Since then, approximately 10 such centers have been set up. Then later, on 11 March 2011, a tsunami was triggered by an earthquake off the coast of Japan. All 4 verification technologies in the IMS contributed data regarding that event. The seismic sensors detected the earthquake and the several thousand aftershocks. Hydroacoustic stations recorded the rupture of the Earth's crust and the tsunami wave. Infrasound stations detected explosions inside the Fukushima Daiichi nuclear power plant. And radionuclide stations detected the subsequent radioactive emissions that were released by the damaged plant. The primary international response was the operation of the Joint Radiation Emergency Management Plan of the international organizations, which is operated by the Interagency Committee on Radiological and Nuclear Emergencies, with the coordinating role of the International Atomic Energy Agency, the IAEA, in Vienna. Although both the IAEA and the CTBTO Preparatory Commission are headquartered together in the Vienna International Center, up until that time there had been very little or actually no cooperation between the 2 organizations during the 15-year existence of the PrepCom. That's due to the very distinct mandates of the 2 organizations and their different memberships. However, in the aftermath of the Fukushima disaster, it was discovered that the IMS data was uniquely valuable for determining the dispersion of the radioactivity globally and the movement of the radioactive plume in Japan. From the outset, the 2 organizations were giving their separate technical briefings in the Vienna International Center, with the member states running back and forth if they belong to both of these organizations. And within 10 days, though, at the request of member states, the 2 organizations were asked to integrate their data and give a joint briefing so that everyone could understand what was happening. This was done, and eventually both the IAEA and the World Health Organization, at the request of member states, were allowed to have access to the data. in addition, the atmospheric transport modeling technology, which had been developed jointly by the Preparatory Commission and the World Meteorological Organization in Geneva, then predictions could be made with 95% accuracy of which countries were going to be affected globally by the radioactive releases. As a result of the IMS's high sensitivity, the concentration levels detected were determined to be generally not harmful for human beings outside the immediate zone of Japan, which contributed greatly to calming down the populations around the planet. By the end of May 2011, activity concentrations at most IMS stations globally had returned to background levels. I was forgetting my slideshow. You can see this 337 facilities. It's quite widespread around the planet. So it eliminated for the rest of the world the human health and safety concerns. The third case is the Organization for Security and Cooperation in Europe and its deployment in Ukraine. The OSCE, the Organizations for Security and Cooperation in Europe, emerged over time from the 1975 Helsinki Accords, the Helsinki Final Act, which was a political arrangement concluded during the Cold War to promote détente between the Soviet Union, the Warsaw Pact countries, and the West. It was originally conceived as the Conference for Security and Cooperation in Europe, the CSCE, as a forum for periodic discussions based on 10 principles. It represented a bargain. The territorial boundaries and spheres of influence in the East and West Europe were recognized in exchange for recognition that human rights were a legitimate topic of discussion between states. At the end of the Cold War, under the 1990 Charter of Paris for a New Europe, which was another politically binding document concluded by the OSCE states, they established a secretariat and began establishing the other executive structures comprising the OSCE. In 1995, the name was formally changed from CSCE to OSCE, that is, from conference to organization. And however, states made it explicitly clear that the name change had no further implications for the nature of the organization or its politically binding commitments. All of these OSCE documents make it explicitly clear that they're politically binding and they're not eligible for registration under Article 102 of the UN Charter. This is intended, it is thought, to preserve a degree of flexibility in the functioning of the organization. So at the present time, it's not treaty-based, and in its fragmented structure, the OSCE currently comprises the Secretariat in Vienna and Prague, 3 institutions in Warsaw, The Hague, and Vienna, 18 field operations hosted in 16 countries from Albania to Kyrgyzstan, the Parliamentary Assembly in Copenhagen, and the Court of Conciliation and Arbitration in Geneva. The various executive structures were established on the basis of the politically binding documents agreed by consensus of the OSCE's 57 participating states. However, there's no consensus on whether the OSCE itself enjoys international legal personality, national legal personality, or any legal personality at all. Oops, this was this slide that needs fixing. You see how fragmented we are. All those little lines are actually kind of legal lines because they represent memoranda of understanding that were concluded with the respective host states that give us some sort of legal capacity where we're operating. Where there's no line at all, it means that there's nothing. I mean, there has been a new constitution and an abolition of decrees in Poland, so we presently have lost our status there, but it's on the way to being fixed. And there's one field operation there in which we have nothing. We just have persons who are deployed there, foreigners, gathering information and sending it outside, and they have no status at all. The answer was, well, you can have their countries give them diplomatic passports. But we would see that under the Vienna Convention on Diplomatic Relations, just carrying around that passport really doesn't give you much protection when there's no sending or receiving state, and you're not in transit, you're actually doing something there. So, but in 1993, the foreign ministers recognized that this is some sort of problem, and so at their council session in Rome, they adopted a decision that each state should, on a national basis, under national legislation or measures, give some sort of legal capacity to the OSCE and privileges and immunities to its staff members so that it could function. But there's only a handful of states that have done anything about this. There was a concerted effort in 2007 to negotiate a draft convention on the international legal personality, legal capacity, and privileges and immunities of the OSCE, which Niels was a very important part of that process. In 7 months, they got the convention drafted and agreed at expert group level, but at the ministerial or the summit level, it has not been approved. In the 8 years since, there's an informal working group that has been trying to do something about this, but they've not achieved any success. So now we come to 2014, and we have the Ukrainian crisis. On the 21st of March, 2014, the OSCE Permanent Council established a new OSCE field operation, the Special Monitoring Mission to Ukraine, and tasked the Secretary General to deploy within 24 hours, which he did, gathering up whoever was spare, got shipped off to Ukraine, and they started carrying out the activities they were supposed to carry out to the best of their ability. I mean, that does underscore just how flexible an organization can be. The intended purpose of that monitoring mission was to restore peace and security, to protect human rights, and deal with this humanitarian crisis that was developing. The rest of the international community has seen that it's fine for OSCE to have a central role in carrying out that mandate, which we've been doing ever since. It was initially intended to be 100 members in this, 100 civilian monitors, expandable to 500, and later this year with the Minsk agreement, that's been expanded to 1,000 for monitoring and verification of the ceasefire and withdrawal of heavy equipment and weapons under the Minsk agreements. So for this purpose, we had to start from scratch and develop this memorandum of understanding with the government of Ukraine. So we started the negotiations in the legal office immediately on the 21st of March. By the 14th of April, we had a signed agreement. It was ratified by the Parliament of Ukraine on the 29th of May and entered into force on the 13th of June, which this is exceptionally record time. And especially in a crisis situation, negotiations and ratification by Parliament can become disruptive or even inoperative. So with the cooperation of the government, everything went really well and we achieved this. But even so, for the first 3 weeks from deployment, we had no legal status or capacity. Upon signature, there was a provisional application of the legal capacity provision. And it was only then that we could, for example, open a bank account or start bringing in equipment under our own name instead of just under the personal name of the people who were driving them. But it was a full 12 weeks before we had any privileges and immunities or any protection of security guarantees by the host state. In those 12 weeks, we were carrying out the mandated activities, we were accountable, we were exposed to an uncertain liability for any damages caused or suffered by the monitors, and we do note that during that period, 8 monitors were abducted and held for a month by armed groups. And there were many questions coming to the legal office. What is the status of those people? So we had a very interesting time with having long discussions about that. But this situation does put persons at risk, and insurance coverage does not mitigate that risk. Not having the legal status means you cannot open bank accounts, enter into contracts, import vehicles or armored vehicles, which were very needed. There's no official status for the people. And as the 1949 advisory opinion on the reparations case said, the organization, when they're deploying persons into risky areas, need to provide them with adequate protection. The decision to undertake high-risk activities must be accompanied by the decision to establish the prerequisite legal protections enabling such a decision to be implemented in a legally responsible manner, including taking into account the duty of care, protection, and security. There are operational consequences and expense to that. When states wanted to loan us unarmed, unmanned aerial vehicles as force multipliers in this exercise, they decided that we did not have the legal capacity to conclude SOFAs to receive this equipment from the militaries that wanted to provide them. So we had to go out on a commercial basis and procure these. So it's a continuing great expense, this problem that we have. It is just an internal debate. Publicly around the world, there is a perception that, that we are functioning as any of our sister organizations, that we're treated that way. We're not really having any big problems except these headaches at the borders. And so while we objectively enjoy an international legal personality, we argue, and we're looking at the reparations case, there's no consensus on that view, and it's also not supported by scholarly writing. It's a very weak legal argument, but under the circumstances, the Secretariat doesn't have anything else but to argue. Either objectively we enjoy international legal personality, and customarily we enjoy privileges and immunities, or if we are just a fiction, then the OSCE is an instrument through which a collectivity of member states, 57 states, are acting. The organs are common organs, and the member states are jointly performing certain acts. So in one way or another, we have immunity. Either we have immunity in our own right, in this objective way, or we have immunity derived from the states that are collectively operating together. This 40 years that we've been in existence, it's a good point in time in this Helsinki Plus 40 to agree something to solve this problem, but politically it looks like we're further away from that than ever. The OSCE has adapted marvelously to its ambiguous status all along the way over these 40 years, doing whatever it was asked to do, and with this attitude of so far so good and preservation of flexibility. Then people seem to be somewhat happy, but for the legal office, it's quite a worry. Some people have likened the OSCE to Houdini, tied up in ropes and chains and thrown into a tank of water to watch it struggle to the top. Others have said that the OSCE has been made to walk on water. And while this may be a matter of light conversation or a question of some academic interest, hopefully scholarly interest into this question, let us not forget that what we are speaking of here is legal protection for human safety and security, both of the 4,000 individuals who are dedicated to delivering the OSCE's mandate, as well as the 1 billion individuals who are hoping to be the beneficiaries of the OSCE's principles and commitments. And that is peace and security across the OSCE region, from Vancouver to Vladivostok, economic development, environmental protection, democracy, and human rights. Thank you very much.
Thank you very much. Marvelous adaptation, as we heard from the first two speakers, causing headaches for legal advisors. All these legal techniques like implied powers, practice of the organization, presumption of validity in the certain expenses case. So it's very fascinating what we see in practice. Let's now quickly go to our third speaker to see if there's additional lessons to be learned from practice.
Well, thank you. When you came in here today, I don't imagine a lot of you came with the perspective or the view that the United Nations has a reputation for being extremely flexible and adaptable. But after hearing from Steve and now me, I think you may leave with the idea that it is downright a leader in innovation. Because I too have a very positive story to tell about adaptability and change in the UN, although mine has a little bit of a Dickens twist. In terms of adaptability, it's a little bit of the best of times and a little bit of the worst of times. So I'm just going to speak about one case example, unlike the wealth of material that Steve and Lisa have talked about, and it is the context of the sanctions power of the Security Council, and in particular the Al-Qaeda sanctions regime and the Office of the Ombudsperson. But although it's one example, it's actually a very good study, I think, in a way, of the dynamics of change and adaptation in the context of the UN. So the sanctions power, when as envisaged by the drafters of the Charter and as originally implemented, was a big power. It was seen as a means of employing diplomatic and economic measures in order basically to cripple and isolate states in the face of threats to international security. And it was used in that way, not frequently, but in the initial stages of the UN, with varying degrees of success. But in accordance with the theme of the conference, times changed and the world evolved, and the circumstances surrounding the use of that power also changed quite dramatically, raising questions about its effectiveness and its appropriateness. The nature of the threats started to change so that the use of the sanction power in that way of comprehensive, crippling sanctions was not as easy to employ. The economic landscape changed so that trying to do this in a way that it was aimed only at a state or states was very difficult and became increasingly difficult. And perhaps most significantly, serious questions began to arise about the side effects, the unanticipated perhaps or unforeseen side effects on the innocent populations involved. And all of this really came to a head with the sanctions imposed against Iraq in the context of the invasion of Kuwait, which led to essentially a humanitarian crisis in the country because of the effects of these measures on the population. And that humanitarian crisis, the program instituted at the UN in order to try and address the problems arising from the use of the sanctions, turned itself into an entire corruption scandal, the oil for food program. So in the aftermath of these issues arising in terms of the traditional use of the sanction power, it's a bit wondrous that the Security Council didn't at that point simply abandon the power completely. But whether because of the personalities at the time, because of the political climate, which was pretty good at the time, or simply because of the continuing need to have something between soldiers and statements, in fact, we see quite the opposite than abandonment. We see, in fact, the rise of the use of the sanction power, gradual rise to the point today where some say the Council's a bit trigger-happy in terms of sanctions. But importantly, an entirely adapted and new form of use of the sanction power, in particular, the migration to the use of what we call targeted or smart sanctions. So instead of aiming at the states, the sanctions are now much more precise and aim at individuals or entities or sectors responsible for the particular threat involved. That itself, and we've gone from the initial cases in the former Yugoslavia, in Haiti, to today where I think it's up to 16 targeted sanction regimes, and it's in and of itself an example of an adaptation by the Security Council, a very creative one. But that migration is not the whole story about adaptation in this context. In 1999, in the course of these targeted sanctions, the Security Council adopted the now famous, and perhaps in some quarters infamous, Security Council Resolution 1267. And this was aimed at, it arose from the circumstances of the attacks, the tragic bombings in Africa against in Kenya and Tanzania, the US embassies there. And the evidence gathered attributed those crimes to Osama bin Laden and Al-Qaeda, and at the time he was in Afghanistan. And in an effort to get him turned over, the Council wanted to impose measures, sanction measures, but they chose not to do so against the already war-weary Afghanistan. They directed them at a faction, political faction, the Taliban, which was sheltering bin Laden, imposing 3 measures, which are still in place today: the international asset freeze, travel ban, and weapons prohibition. And they set up a committee to say who are the members of the Taliban against whom these measures should be directed. And it went along without much fuss at that time because there was a very small number of people went on the list. Then in 2000, they made what would have been described as a small amendment. It turned out to be rather a significant amendment because they added Osama bin Laden himself and members of al-Qaeda to the subjects of the targets of the sanctions. The first time the Council is now directing their power, their very big power, directly at non-state actors in a global basis, because al-Qaeda is about global jihad. And that too didn't have a particular ramification immediately, but after the tragic events of 9/11, hundreds of names go on to the al-Qaeda Taliban list, and suddenly there is a serious situation that needs to be addressed because you have a very political body, the most political body in the world, using legal measures against individuals without the normal accompaniments of recourse, reasons, notice, fair process. And that created a situation that cried out for change and adaptability. And it took a little time. And what's interesting in terms of analyzing change is it took a chorus of voices to drive the change, the quite dramatic change that ultimately developed. Academics came in early and often writing about the situation with these sanctions. Human rights officials, from the High Commissioner to the Special Rapporteurs, began to comment on the situation. States, having to implement these measures, began to criticize the situation as it stood, and it led to the creation of a very powerful coalition, which we like to refer to as the like-minded group of states on sanctions, that really worked political miracles in lobbying for change in this context. Often forgotten, but essential, Secretary General Kofi Annan at the time took a very personal interest in this issue, and with the assistance of the then legal advisor, Nicolas Michel, not only added his voice to the critique of the Security Council, but came forward with a set of principles of how fair process should look at the international level, principles which certainly I use and the Council used in its innovation. And finally, of course, the courts. It was inevitable. When you take a man who had had sanctions imposed on him for 10 years, he had all his assets frozen, and he couldn't move anywhere, and he had nowhere to go, no recourse, and you put that in front of the European Court of Justice, I don't think anyone really should have been surprised that ultimately, whatever the Charter may say, they were not going to turn the other way. So 2008, the European Court of Justice strikes down the implementing legislation for the al-Qaeda sanctions regime in the European Union, and that gets a little bit more attention on the issue, as you can imagine, in the hallways in New York. And it led to me, basically. It led to the creation by the Security Council of the Office of the Ombudsperson, effectively at the international level, a review mechanism for these sanction measures. And I won't go into detail, but basically a process whereby if you're on the list, you can come to me directly. You don't need a lawyer. Most of the requests come in by email. I will start a process and I will gather the information in the case. Then I engage with the petitioner and disclose the information about the case to him. And I usually do that by a face-to-face meeting. And then I prepare a comprehensive report for the Sanctions Committee. And this changed about a year in. I was given, in addition, a recommendation power. And even more importantly, in terms of the dramatic nature of the innovation, if I recommend retention, the listing will be retained. If I recommend Delisting, then even if there is not consensus, 60 days later that entity or individual is coming off the list unless all 15 members of the committee, which parallels the Security Council, agree and contrary to my recommendation. As you can imagine, that's a bit tricky. Or the matter is referred to the Security Council for a vote, which we refer to as the nuclear option. As neither of those eventualities has happened, what we have now, effectively, is an independent review mechanism, which I have assessed in each case, and I've told the Security Council in my reports, is operating to give fair process to these individuals in each of these cases and giving them an effective remedy. And it's not just an effective remedy in a casual or occasional case. I've had 63 applications. One of my big fears when I took well, I had many fears, but one of my big fears was, is anyone going to actually use this? And the answer to that has been a resounding yes. 63 applications, 48 completed cases, 39 individuals delisted, 29 entities delisted, 6 retentions to date. And that, I think on this particular point, I think the fact that it's been used is, well, it's a testament to the need for the mechanism. It's also a credit to the Council and the way in which they crafted a very robust and respectable mechanism. And I like to think it's also attributable to credible implementation. And on this point, I'm compelled by circumstances to convey a particular message, and I don't do this from any point of arrogance because there are many people with the right experience to do this job very well. But what the evolution of this mechanism has told us is that the individual who holds the post not only needs to have the right mix of skills and qualities, but they need to be seen and perceived to have those qualifications. And if they are not seen that way, this mechanism will not function. It will not gain the trust of the Council and the states, and it will not gain the trust of the petitioners and the lawyers who represent them. And when it becomes bound down to it, it will be back to a choice between the mechanism and the courts, and we'll be right back where we started. So, message delivered. Looking back where we've come in a 5-year period, I think it can only be said that this is a success story. And it's interesting in the context where the Security Council faces withering criticism day in, day out. This is a success story attributable to the Council, and they do not get sufficient credit, especially in Luxembourg, in the European Court of Justice, for the adaptation and the change that they brought in terms of fair process. Now, I said I had a little Dickens side to this story, and I have to relate that. All is not rosy in the context of this adaptation and change. There are still significant critics of the process who say it has not gone far enough. There is still, in principle, the ability to overturn, so it's not a binding mechanism. There is still the fact that there's 16 regimes and there's one ombudsperson attached to one regime. On the other hand, there's a whole quarter out there for whom this is not a very welcome change, who consider this an incursion into the powers of the Council. And those voices are being raised lately, temperature going up a bit. I've been called destructive, narrow-minded, terrorist sympathizer, and said to be obsessed with fair process. The last one, probably true. But they are important and serious concerns because they affect the credibility of the mechanism, and they affect our ability to improve it and to sustain it even. And thirdly, and for me the most disappointing, we have had this remarkable change by the Security Council, this remarkable development by the political body, but it has not been accompanied by sufficient flexibility or creativity in this part of the Secretariat that services the Security Council. And in particular, this was a golden opportunity to institutionalize an important rule of law, fair process mechanism, and that opportunity has not been taken. While the resolution called for the establishment of an office of the Ombudsperson, it does not exist in the UN system. A consultancy contract has been used, there's been no post created, and that creates massive problems in terms of managing resources and staff in an independent way. And most significantly, and this will not be lost on this audience, there's not a single institutional protection for the independence of the office. It is simply dependent entirely on personalities. And as you can imagine, that's a pretty fragile way to protect independence in an international context. So unfortunately, for me, that's the biggest threat to the mechanisms, to its being sustained and improved. And it's ironic that it comes from a lack of change within the very organization supporting the political body that came up with this innovation. But I won't conclude on a negative point, because I'm Canadian after all, and we're endlessly optimistic, and plus I'd have to apologize if I did that. So I think the perspective on this is very clearly that in the big picture, whatever the fate ultimately of the mechanism itself, it is a perfect example that international organizations can change and adapt, that highly political bodies can change and adapt. And they can do so in aid of, in support of, the rule of law and fair process at the international level. And I think that's an enormous lesson we can take and goal in other contexts as we move forward. Thanks very much.
Thank you very much. So that is essentially another success story on adaptation. But it's too early to jump to conclusions, because we have our final speaker, Professor Reinisch. August, please, you have the floor.
Well, Niels, thank you very much for inviting me to this panel. It has been a terrific panel, and I've learned so many new things. I've given some discretion to look not so much on the practical implementation of adaptation, but rather to reflect a little bit on the consequences that maybe we as scholars would draw from that. I don't know how much flexibility I have with regard to our time budget, because I have realized that we are a little bit short of that. So I try to be very brief. We've just heard that organizations are around for probably a good 100 years, if we think of the League of Nations, or actually, as our chairman has just mentioned, maybe 200 years, because it was exactly 200 years ago that the first river commissions or other administrative unions were founded. And as I said, looking at the adaptations that are necessary more from a kind of history of ideas, or how courts and scholars have reflected on the changes performed by international organizations, I'm trying to, at all the risk of oversimplification, focus on two main points. On the one hand, the need to establish the independence of international organizations. And we've heard from Lisa Tabassi that this is partly something very, very practical and real still. So I would position that more in the kind of 20th century narrative, or second half of 20th century. And looking at today's need, second part would rather be the need to establish a working accountability. So it's in this kind of framework that my brief remarks are directed towards. Now, first one, the need to establish the independence of international organizations. For a long time, and we've been reminded of that again today, organizations have been regarded basically as collective undertakings of their member states. After some time, it was recognized that even their definitional characteristic contains some kind of independent will or volonté distinct, and states still have been reluctant, fairly reluctant, to truly regard them as independent entities. So very often, even today, this paradigm of organizations as a fora for member state action has and is still prevailing over international organizations as independent actors. Now, the reasons from a public international law perspective, could on the one hand be a kind of overemphasizing of the pacta tertiis principle. States have often insisted that international organizations enjoy an international legal personality only between the member states or vis-à-vis other states that have expressly recognized them. And I just remind you of the long-standing doctrinal debate, Finn Sejersted, objective international legal personality, which was not only rejected by Soviet scholars, but also by mainstream scholars in many other countries. Now, with the reparations opinion, and I'm always fascinated how much this is still around and everybody uses it and has to use it, it seems that, at least for the UN, the objective international legal personality was very much recognized. And I just want to remind you what it said. At the time, 50 states representing the vast majority of the members of the international community had the power, in conformity with international law, to bring into being an entity possessing objective international personality and not merely personality recognized by them alone. What fascinates me is that meanwhile, this seems to be, although not everywhere fully explicitly, but de facto, this is recognized by almost all organizations. And I think, Lisa, you should be much more forceful in driving that point home to the participating states in the former conference and now organization for security and cooperation in Europe. Now, functionalism has been the main driving doctrinal tool to establish the international legal personality of organizations. The European Court of Justice has been mentioned. It has been a champion in developing implied powers doctrine to a degree that for us Europeans it's often very hard to understand what could not be an implied power. So in that sense, we have a fairly clear development over the last 50 years at least with regard to international organizations, theory and scholarship, establishing the functional independence of those creatures of states. We have now, far more recently, and that really is just maybe a 20 years exercise, more and more the recognition that it's not so much the separate legal personality and independence, but rather the issue whether these new actors under international law, which perform so many tasks, and we've just heard how many tasks are performed according to their original constituent mandates, but also according to adaptations to these original mandates. Think of organizations delivering health, flight security, financial, overall peace services. Now, with all these services, public goods developed and delivered by international organizations, they often encounter practical difficulties. Should a specific development bank disperse a project loan in a country where there is a serious suspicion that part of the money may be used in a non-transparent way, possibly violating human rights of indigenous peoples? I see people in this room who have written a lot about these topics. Should a technical organization regulating air traffic security in Europe comply with antitrust competition law rules? Should the UN go into certain regions, pull out of certain regions when conflicts may escalate? Now, we are all aware that these are not hypothetical questions. International organizations, the UN has been charged of failure to stop the genocide in Srebrenica and Rwanda. The World Bank has been accused of disregarding human rights in a number of very specific projects. Eurocontrol and OPEC have been sued in different countries for violating the EU competition rules or US antitrust law. Now, I think this is just witness of the fact, the simple fact, that organizations have been endowed with more and more powers, have used them, and sometimes in the course of delivering the public services and goods, something may go wrong. And that, of course, the increase of services lead to a kind of statistical probability of something going wrong, and I'm very deliberately vague here. Organizations have increasingly been asked to account for actions or non-actions. We've heard by Kimberley the process about the country sanctions in Iraq. They have been called to respond to what they did or what they didn't do. Now that has led in the last 10, 20 years to an interesting turn in international organization scholarship. So you see that also scholars are able to adapt to changing circumstances if the objects of their studies change or their behavior changes. International organizations have led to an ILA committee on the accountability of international organizations, which has elaborated in 2004 a rather elaborate set of recommended rules and practices, to a large extent inspired not just by strict legal considerations, but good governance ideas in what should be the policy behind organizations' action. Then, of course, being successful or having successfully completed the state responsibility articles, the ILC took on the task to develop articles on the responsibility of international organizations. In a parallel development, global administrative law scholars have realized that there may be something developing very similar to domestic administrative law, and principles, maybe general principles, could be transferred from one field to another. And even if there are administrative lawyers, there must be constitutionalists. Of course, constitutionalism debate has also contributed quite a lot to many of the specific issues that we've discussed today, from peacekeeping to sanctions problems, etc. So that in turn, and one could also say this is a kind of more rapid adaptation of scholarship, it would be very difficult today to question that international organizations, being recognized as separate and independent persons, can actually incur legal responsibility and accountability. The ILC articles, which are very clear in premising the responsibility on the commission of international wrongful acts. Now, what they of course cannot deliver and were never meant to deliver, these articles on responsibility, is the problem we really are facing today. We don't know what the wrongful acts are. I mean, maybe a little bit exaggerating. We sometimes have an idea. But if we compare the two sets, state responsibility, IO responsibility, with states it's fairly clear. They have entered into numerous treaties, they are subject to customary international law, general principles of law. So the whole wealth of sources is available to identify primary obligations of states that from time to time will be disrespected. If we take this template and if we apply and try to use it for international organizations, we realize that states, well, they do international organizations, of course, do very often enjoy treaty-making power, but they don't very often use it. If we look at the actual treaties entered into by organizations, it's a fairly disappointing record, I should say. Of course, the host agreements, that would be very important, but what about treaties that impose obligations? And in the debate about peacekeeping, but also in the sanctions debate, we've realized that, of course, none of the human rights or humanitarian law treaties have organizations as parties. And even in the one regional international organization where everybody since Lisbon thought that it's just a question of a few months that the European Union will become a party of the European Convention on Human Rights, this is further away than ever. Now, no wonder that scholarship has turned towards customary international law. And I'm aware of Neil's reminder of the time. Now, customary international law is something like the miraculous rescue when it comes to find obligations, not only for states that haven't ratified treaties, but apparently also for international organizations. But at the same time, it's very unclear what kind of custom could actually bind international organizations. And I'm particularly fascinated by the current debate in the ILC on the identification of custom, and in particular, not only by the reports, but also the member state comments in the 6th committee, when it comes to the degree that international organizations' practice should be considered or not. And you will be not surprised that the majority of states are very reluctant. Now, that has two sides. It has two sides. On the one hand, of course, states may reserve their home turf and exclude other players, but it also means that other players are not bound by the rules that they, of course, the states are usually bound. So let me cut this short and just try to give you the very brief history of international organizations in 30 seconds. We have established that organizations enjoy an independent personality. That's fairly accepted with very minor exceptions. We have also largely accepted that they have the potential to actually incur obligations and to become responsible for violations, but we are now back to the very fundamental problem of international law, and that is a problem of the applicable sources. We don't know exactly what kind of obligations they have. Thank you.
Thank you very much, August, for these reflections. And, well, ladies and gentlemen, I think we have offered you a very interesting lunch. And we have still some time for questions. Who could I give the floor? Let's first try to see if we have perhaps 3 questions. Yes, please.
Thank you. Does it work?
Yeah. Yes, it works. Perhaps you could identify yourself, Mr. Bucci.
Yes. Well, you identified me, sir. Gianluca Burci, World Health Organization. Many thanks to the panel. Really very, very interesting, both conceptually and practically. Now, I have 2 comments to which I would welcome the response, in particular by Stephen and Lisa as the practitioners on the panel. And it has to do with maybe less spectacular adaptation. But to me, having worked by now 27 years in the UN system, especially after the end of the Cold War, is very visible in, I would say, structural and the culture of international organization. One is what I would call the increasing importance of corporate and private interest in international organization. just the assumption of management style. We talk about value for money, we talk about client responsiveness, we talk about the absolutely legitimate corporate concept that would have been kind of alien to the language of international organization 20 years ago. So we look at the fundamentally public bodies through an increasingly corporate lens. Another example is the proliferation of oversight bodies, the enforcement of the accountability that August was talking about, very visible in the UN, visible also in my agency with the proliferation of oversight bodies and audits. The second is in a way, the increase in the importance of private sector. Maybe once again, less visible in the security and political area of the UN, very visible in the technical area, certainly in my organization. And that translates in many adaptations and in many doubts as what the future can bring, whether it's a slippery slope towards the abandonment of a purely public concept of international organization, but an increasingly hybridization or corporatization of international organization. For example, in WHO, the largest donor to WHO is the Bill and Melinda Gates Foundation. They give us substantially more money than the United States. And that is such a distortion, but it's so emblematic in a way of the way in which maybe international cooperation is moving. The second is the need to sideline a public governance and to bring corporate actors to the decision-making table. For example, through the creation of these public-private partnerships that are hosted by international organizations and that have private actors in the board. So they take decisions together with sovereign member states and together with us. I think we still have to fully understand the implication of this change. So I would appreciate a reaction if you share my concern in a way, or at least whether you see this as a trend, not just an incident or an episode, but a trend to a change in philosophy in the way at least UN system organizations are perceived. The second very quick comment is the adaptation in the very notion of international organization that follows up on what I was saying. And for example, the proliferation in technical areas like education, like sport, like environment, like health, of these new public-private platforms, like for example the Global Fund in the health area, which is a Swiss foundation formally, but behaves for all intents and purposes like an international organization with a hybrid board, with fundamental international functions, has been invited by the General Assembly to attend as an observer, so high-level political legitimacy, if you want, has even, and that's not, it's interesting, it escaped the attention of scholars, adopted its own convention on privileges and immunities, the first ever hybrid body that has its own convention on P&Is. And so whether you can see this as a trend to avoid the creation of new international agencies, but to provide the public goods that August was talking about by other means, and whether this also can be a trend that will change fundamentally the way we look at international organization as entities. Thank you.
Thank you very much. Other questions from the audience? Yes, please, over there.
Thank you. My name is Nimrod Karin from NYU School of Law. My question is mainly for Mr. Mathias, and I will be glad to hear Professor Reinish's opinion on it as well. Mr. Mathias, you spoke about the role of lawyers in UN adaptation, and my question concerns attorney-client privilege within the UN system, and specifically I'm referring to legal opinions provided by the OLA to the Secretariat, officials and bodies on a range of issues, and there are very few excerpts of these opinions published through the UN Juridical Yearbook, but most of them are remained confidential, and I know from my own personal experience that these confidential opinions are not even provided to member states when they request. So I'm wondering, in your view, what is the legal basis, international legal basis for this kind of privilege, and who are the beneficiaries of these privilege, and who may waive it? Thank you.
Thank you. Any further questions? If not, then also in view of the time, let me straight away go to the panelists and ask them to respond to the questions that have been put to you. First of all, please, Steve. Sure.
Well, thank you for both of those questions. As to Gianluca's questions about increased private interest in international organizations and perhaps the introduction of sort of corporate mentality. And I think my own perception is at the United Nations that while, of course, we do see as a trend increasing interest by private persons and by private companies in the work of the organization, I think we've been quite insistent, really, on maintaining the independent nature of the organization and the traditional characteristics associated with the international civil servant process. I mean, I think in a way, the comment that you made about the Global Fund and that kind of entity is at tension a little bit, in tension a little bit with your observation about private partnerships taking over the established international organizations, if I can put it that way. In other words, I think the reason why entities like the Global Fund are set up as they are outside a structure of a traditional IO is because the traditional IOs insist on complying with certain fundamental rules about the way they're going to do business that the people organizing these entities don't want to comply with. And so I think there continues to be a distinction between those two things. In terms of the attorney-client privilege and the legal opinions of the Office of Legal Affairs, of course, many of them are published in the Juridical Yearbook, and we have an exercise actually going on now, and some of my colleagues in the audience who are working on that are here, to go back over previous work of the office that has not previously been published and to make those public, and we'll be doing that even later this spring. At the same time, I think it is important to maintain the possibility of legal advice remaining confidential within the organization. And I think who are the beneficiaries of that? Hopefully, it's all of you in this room and the international community. In other words, the UN policymakers need to get our best advice on the legal aspects of issues that are coming before them, but it would not necessarily be in anyone's interest to have that public in such a way that our ability to provide that advice as part of a deliberative process would be undermined. So I think there continues to be a role for confidentiality, but we are also looking to try to make as much information public as we can.
Thank you very much. Lisa, I hope you can give your reply in a minute or so.
I would just add on the question of private partners with the international organization that at least for some of the technical ones, without the buy-in from industry, the organization, at least in the example of the Chemical Weapons Convention, it was only after chemical industry became totally supportive of the process and the verification regime that was going to be established that they were able to reach agreement on the text of the treaty with the verification regime. And it was the lack of support by industry for the biological weapons protocol that prevented that protocol from ever being concluded. They just didn't believe that this verification regime was going to be credible or not risk potential release of very sensitive industrial secrets in the biochemistry field. So, but then the other reason why they're getting involved is funding. I mean, this zero nominal growth or zero real growth in the best case scenario, zero nominal growth in the worst case scenario, has meant that these budgets are just not growing. And at the same time, the expectations of everything we're supposed to do keep increasing with no increase to resources. So it's put everyone under a lot of pressure, and there's no place to go for the money but in some cases to private industry. And it has led, this hybrid thing has led to some strange things, like when we had to go for open tender and commercially get a drone system and drone operators into Ukraine. Fortunately, the memorandum of understanding provided that persons performing services for the mission could also be considered to be members of the mission, because it would have been very difficult to convince this commercial supplier to bring the drones to Ukraine and provide that service unless we could give, they don't have full diplomatic protection, but they do have a lot of facilities offered to them that convince them to come and give them some degree of protection, which for me was a really weird thing that we would give that to a commercial entity, but that is what's happening. But yeah, the public-private partnership, we're headed down that road, and there's just no way around it because the governments are just not going to come up with extra money.
Thank you very much. Kim, please. No, August. Final minute.
5 minutes over, but if I may, just very briefly on the transparency issue. Of course, as a scholar, you want to know everything, and all the opinions should be public. But it reminds me a little bit of the debate we had in UNCITRAL very recently about transparency in investment arbitration. Of course, you cannot say anything against the transparency. We are talking about public interest, it should be public. But don't forget, there may be an interest of some states that not everybody knows why they may be sued next day.
Thank you very much. Kim.
Sorry,
Final
I just had one, he just spurred me. I actually come to this issue of privilege from a very different point of view. I would love to be able to release the comprehensive reports, the 48 of them that I've written, but they remain confidential, and I think that has a real effect on the credibility, transparency of the process. So I'm with you. I'd like it all out there, but I'm in the minority, I guess.
Thank you very much. We heard already in the other room a big applause for their panel. I think we can do this as well here. Thank you very much.